Swayam Prabha. Digital India. Educated India.
Well, students, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU. And this is my 18th lecture, to which I am going to present before you. So, the topic of today's discussion is rights of victim of crime under Indian criminal justice system. So, in this lecture, we will try to understand what are the rights of victim of crime and what rights are available to victim of crime in our constitution or statute. Statute here means what rights are available to victim of crime in criminal procedure code or other special statute like domestic violence act. And the third important thing is that to what extent Supreme Court has been effective in protection of rights of victim of crime. So, in the light of these three legal framework, in the light of these three important components, we will try to understand the rights of victim of crime under Indian Constitution, rights of victim of crime under the statute, and judiciary, how to what extent Supreme Court has played important role in protection of rights of victim of crime. And first of all, I would like to give precise definition of victim of crime. The first question which may arise, that who is victim of crime? You all might be knowing that in our legal system, the entire focus on criminal justice system is to protect the rights of accused under Indian criminal justice system. And because of that reason, we always means Indian criminal justice system has always been emphasizing the rights of accused. The irony of law is that accused who has committed crime, committed murder, and is entitled to get right to legal aid, right to free legal aid, right to medical aid. Being accused, being a criminal, he is also entitled to get all the benefits which he can claim because of human rights, because of other statutory. And the basic concept behind giving all these liberty to the accused is presumption of innocence. Every person is presumed to be innocent unless his guilt is proved before the court of law. So, because of presumption of innocence, every person is presumed to be innocent unless his guilt is proved, though he has committed murder. You see, you might have seen that even media also attracts the attention of jail authorities that accused criminals, they are not getting proper food in prison because the jail authorities has failed to provide pulse and breads to the accused. But you might have seen that media never attract the attention of that victim of crime who has lost his brother, who has lost his father or mother, who has been killed in that crime. Media never attracts the attention of victim of crime. Media never try to attract whether the victim of crime who has lost his father or brother, whether they are getting food properly or not, whether they are getting proper financial assistance or not, they are poor, they are not in position to manage their food. So, that part is always lacking in our criminal justice system. We never think about the rights of victim of crime. So, considering the gravity of that issue, rights of victim of crime, criminal justice system, Malimat committee for the first time made recommendation that victim of crime must be provided certain rights under criminal justice system. So, Malimat committee on criminal law reform 2003 has made several recommendations for the betterment of victim of crime. So, firstly we will try to understand who is victim of crime. Section 2WA of the Code of Criminal Procedure 1973 talks about victim of crime. According to section 2WA of the Code of Criminal Procedure Code CRPC 1973, victim is a person who is sufferer of whose right has been violated, who has been suffered, who has been injured or suffered any loss due to wrongful act of the respondent. So, a person who has suffered loss individually or collectively by the wrong deeds of offender, by the wrongful act of the offender, so that is a victim of crime. So, even the dependent of deceased, where someone has been killed by the offender, the dependent of the deceased. So, for example, let us understand this with the help of illustration. Suppose where a father is killed, father has been murdered by the offender. So, son or daughter of that deceased would be considered as victim of crime. Mother of that wife of the deceased shall be considered as a victim of crime, and she is entitled to get compensation from the accused, and she has certain rights in criminal justice system. So, victim may be individual who himself has suffered injury or loss due to wrongful act of the respondent, or where person is killed, the dependent of the deceased may also be considered as victim of crime for getting justice under Indian criminal justice system. So, you see, you just look on your screen, I have covered this who is victim of crime, section 2WA of CRPC 1973. This victim of crime has been added in Criminal Law Amendment Act 2008. Section 357A, which talks about victim compensation scheme, I will discuss this. Rights of victim of crime I have also covered. So, firstly, I tried to explain victim of crime. Who is victim of crime? Section 2WA has given clear cut definition, precise definition of victim of crime. Now, come to rights of victim of crime. So, you see, I have highlighted 4 important rights: right to file a complaint or right to lodge FIR. Section 2D or 154 CRPC talks about FIR, 2D CRPC talks about complaint. Right to file protest petition. This is another important right of victim of crime. Right to be impleaded in proceeding, right to get compensation. So, these are certain rights which we will try to understand. So, let us discuss these rights one by one. So, you see, right to file complaint, section 2W and 154 CRPC talks about mandatory registration of FIR. So, I have referred a case Lalita Kumari versus State of UP AIR 2040, wherein Supreme Court has categorically held that registration of FIR is mandatory. And 156 I have also highlighted section 156 CRPC FIR by court. So, I would like to discuss this first important right which is available to the victim of crime. You see, in all the democratic countries, the most important right which can be claimed by victim of crime, that is right to lodge FIR or right to file complaint. So, whoever is victim by victim of crime can lodge FIR, first information report, or can file complaint, lodge FIR or file complaint to the court of magistrate. And you see, if I talk about Indian criminal justice system, the moment offence is committed by the offender, at that very moment victim of crime has right to approach the police station, and he or she may ask to the police station that this information should be registered by police officer under section 154 CRPC. So, the moment offence is committed, at that very moment victim of crime has got liberty to lodge FIR at the police station, or she has two options: either she can or he can lodge FIR at the police station, or he or she can file complaint to the court, to the magistrate, and in that complaint or if FIR is lodged, these two procedures are available, two options are available to the victim of crime. Why there are two options? You see, victim may be literate or illiterate. So, where victim whose right has been violated may approach to the police station or court. So, police officer, if she or he is not, victim of crime is not literate, then if he gives information about cognizable offence to the police officer orally, then police officer shall record his statement in writing, and one copy of that FIR information shall be provided to the informant free of cost. This is the procedure what I am trying to. One question before Supreme Court was whether police officer is bound to register FIR under section 154 CRPC, or police officer can refuse to register FIR under section 154 CRPC. So, you see, Supreme Court for the first time in Lalita Kumari versus State of UP AIR 2014 Supreme Court has held that once the information regarding commission of cognizable offence is given to the police officer is under obligation. Police officer shall register the information as first information report. So, you see, mandatory registration of FIR was duly recognized in Lalita Kumari case, Lalita Kumari versus State of UP. Supreme Court said that the word shall used in section 154 CRPC is mandatory provision. The legislative intention behind putting shall word in section 154 CRPC is to impose obligation upon investigating officer, police officer to register FIR information, mandatory, obligatory. So, legislative intention behind, Supreme Court held that we should look legislative intention, we should take notice of section 154 CRPC that legislator deliberately put shall word in section 154. So, police officers, they are bound to register FIR, they cannot refuse to register FIR. Many times you might have seen that just for lodging FIR, victim of crime has to approach, has to knock the door of High Court, and sometimes you might have seen that victim of crime has knocked the door of Supreme Court just because of lodging FIR. So, this thing is very bad for Indian criminal justice system, and you might be aware about two important incidents wherein victim has to knock the door of High Court, then High Court should issue the direction to the police station concerned to so that FIR can be lodged. And ultimately she approached the Supreme Court just for lodging FIR. So, what I am trying to justify, the first right which victim of crime can claim from the authority, that is she can file FIR at the police station. Just by filing FIR, victim of crime can mobilize, can expedite the process, and lodging of FIR gives opportunity to the police officer to start the investigation. And section 154 CRPC, which talks about first information report FIR, just by lodging FIR, it puts investigating agency into criminal law into motion, and just by filing FIR, a police officer is bound to register the FIR and he will start the investigation. Where police officer has refused to lodge FIR, then what is the remedy to that victim of crime against whom crime has been committed? Then he or she can knock the door of superior police authority. Then he or she can send the information to the superintendent of police by post. This remedy is also available under section 154 clause 3, where station head officer SHO has refused to lodge FIR, then being aggrieved, informant can send that information to the superintendent police by post. If superintendent of police has also refused to lodge FIR, superintendent of police either may direct the police officer concerned to lodge FIR or he may also refuse to accept the application. In that case, aggrieved victim of crime has right to knock the door of court. Then it is specifically provided under section 156(3) that victim of crime can approach the court and by FIR may be lodged by as per the direction of judicial magistrate to the court to the police station concerned. Section 156(3) talks about lodging of FIR by judicial intervention. Judicial magistrate may direct the police station head officer concerned to accept that information to lodge the FIR, and FIR will be lodged as per the direction given by judicial magistrate to the station head officer SHO. So, these are the remedy available to the victim of crime: lodging of FIR or complaint. Now, you just look at this slide, right to file protest petition. This is second important remedy available in the hands of victim of crime, right to file protest petition. Where victim of crime is not satisfied, you see I have chosen this right to file protest petition. So, firstly I will try to explain protest petition. What is protest petition? Petition which is filed by a person in protest. So, protest petition is very clear by its nomenclature. Petition which is filed in protest. So, where victim of crime who is not satisfied with the action investigation conducted by investigating officer. So, victim of crime can file protest petition in that very court where final report is submitted by investigating officer. You see section 169 CRPC talks about closure report, where it appears to the investigating officer that there is no sufficient evidence against the accused, there is no adequate evidence against the accused. In that case, it shall be lawful for the investigating officer to close the matter and to file the closure report in that case, and closure report may be submitted by investigating officer in that court under whose jurisdiction offence is committed. So, now matter is closed. Investigating officer has closed the investigation by stating in that report that there is no sufficient evidence against the accused and the allegations made against the accused is baseless, false. So, matter should be closed, and if judicial magistrate is satisfied result with that investigation, then judicial magistrate will put his signature. That report will be sealed and signed by judicial magistrate, and at that very moment matter would be closed. If victim of crime is not satisfied in that situation, she has two options. She can file or he can file protest petition in that court where closure report is submitted by investigating officer by saying that there is no sufficient evidence against the offender. You can understand this with the help of a case which happened in Uttar Pradesh. The name of case is Amarmani Tripathi and others versus state of UP. This case is popularly known as Madhumita Shukla murder case. In what happened in this case, Madhumita Shukla, she was brutally killed by the offender, and in that incident the name of then MLA Amarmani Tripathi and his wife, you see Nidhi Shukla, deceased sister, she lodged FIR, and in that FIR the deceased sister stated entire story, and she stated before the police officer that accused Amarmani and his wife, they were involved in conspiracy, they were involved in killing her sister. As per FIR, investigation was started and police investigating officer filed a closure report in that case that these two were not involved in that incident. So, what you see the point which I want to make you clear that when closure report was filed in Madhumita Shukla murder case, then the deceased sister Nidhi Shukla, she approached the High Court, she filed the protest petition in that very court where closure report was filed. So, she filed a protest petition by saying that she was not satisfied with the investigation conducted by the police officer. So, matter should be reinvestigated and matter should be handed over to the CBI. So, she approached the High Court, she filed petition in High Court. As per High Court direction, matter was referred to the CBI. In the same case, when matter was investigated by CBI, CBI filed a charge sheet in the same case and CBI charge sheeted not only Amarmani Tripathi, but his wife was also charge sheeted in that case, and CBI reached a conclusion that both were involved in killing Madhumita Shukla. With the help of DNA report, with the help of forensic evidence, you see the point which I want to make you clear is that what is the efficacy of protest petition. You see the efficacy of protest petition where protest petition is filed by victim of crime by the deceased sister, she was not satisfied and when protest petition was filed by her, in that case matter was transferred, matter was reinvestigated and you can see the result in that case. So, I do not want to discuss that case in detail here, I just want to highlight only right to file protest petition in such a situation. Second important case on this point which you might be knowing about, RC murder case. RC murder case, in that murder case, her parents, the parents of the deceased Dr. Rajesh Talwar and Nupur Talwar, both were charge sheeted by victim of crime and the Hemraj was also killed. Hemraj was a domestic servant in that case. So, wife of deceased Hemraj, she lodged a FIR against Dr. Rajesh Talwar and Nupur Talwar by stating that Hemraj, deceased Hemraj and RC, they had illicit relationship between Hemraj and RC. So, that is why parents decided to kill both. You see, then when matter was investigated by police, closure report was filed and that got media attraction. It was reported in newspaper that no one killed RC. So, closure report was filed, matter was handed over to the CBI. When matter was reinvestigated, then CBI arrested Dr. Rajesh Talwar and Nupur Talwar for killing their daughter and domestic servant, and ultimately you see trial court awarded them for life imprisonment. They went in appeal and now right now they have been acquitted by the High Court. So, you see the point, the important point is where protest petition is filed by the victim of crime, that protest petition can play important role. Where to whom protest petition can be filed, who can file protest petition, what would be the efficacy, what would be the consequences if protest petition is accepted and matter is reinvestigated. So, you can see the result of Madhumita Shukla murder case and RC murder case. This is how this right is effective and protest petition can play important role in protection of rights of victim of crime. So, this is second important right. Now, you see third important right is incorrect, right to be impleaded in criminal proceeding. Malimath committee, as I have just told you that Malimath committee 2003 has made recommendation that victim of crime should also be given opportunity of hearing by a court before granting bail to the offender. Purpose is to ensure transparency in administration of justice. What is the purpose behind impediment of the victim of crime in criminal proceeding? The sole purpose behind impeding the victim of crime in criminal justice system is to repose the confidence in justice delivery system, to invite him, to invite her, to invite the victim of crime to become part of judicial proceeding, so that he or she can see what is actually going on in the court of law, whether his or her case is being effectively represented by government counsel, by prosecution or not. Earlier what happened, you see, in most of the criminal cases, offender were acquitted due to absence of evidence. After a long debate, after long trial, when trial is conducted, on the date of pronouncement of judgment by the trial court, the trial completed with a single sentence. Now trial is over and accused offenders are found innocent due to absence of evidence. So, it was thought that victim of crime should also be invited, should also be given opportunity to represent his or her case before the court, and he or she can see personally what is actually going on inside the courtroom. So that the purpose is just to repose the confidence in justice delivery system, and the purpose of justice is to maintain public confidence, to maintain the confidence in justice delivery system. So, for that reason, Malimat committee has recommended that victim of crime should be pleaded in judicial proceeding. This is and the purpose which I have already highlighted. For what purpose? Victim of crime should be given opportunity to become part of judicial proceeding. Now, the third important right which can be claimed by victim of crime, that is right to appeal. Right to appeal is provided under section 372 CRPC. 372 CRPC talks about appeal, that unless otherwise provided by this code, every accused or every person shall have right to make an appeal against the order of the court. So, unless otherwise provided by the code, it means this right to appeal is a statutory right, and right to appeal can only be claimed where statute has specifically, where CRPC or any other statute has specifically provided this right, recognized this right in that statute. Otherwise, no one can claim right to appeal as a matter of right. You all might be knowing that there are certain circumstances where appeal is not allowed. In case of petty offences, appeal is not allowed. Section 375, 376 CRPC, you all might be familiar with these two provisions, section 375 and 376, which talks about no appeal in petty offences, where matter is decided by trial court, session court, matter is decided by high court, and punishment is awarded by high court, 6 months imprisonment is awarded, or 1000, 2000 rupees imposed as a fine, then against that judgment no one can move before the Supreme Court. You see, in this kind of situations, people or person are not allowed to make an appeal against this kind of petty offences or this kind of. So, right to appeal is statutory right, where statute has specifically provided that under these circumstances victim of crime can approach the court. So, section 372, I just want to explain it with the help of this slide. You just look at your screen. In case of acquittal or inadequate punishment, victim can make an appeal to the court. The purpose of appeal is to restitution, right to restitution. The purpose of appeal is to maintain status quo ante. Purpose is status quo ante. I just this A and T E, not I. So, right to appeal can be made by victim of crime under two circumstances, where accused is acquitted or sentence awarded by court is inadequate. So, on these two grounds, victim of crime can make an appeal. So, you see, where accused is acquitted or punishment is inadequate, the general rule is that usually prosecution has to make an appeal, because crime is against the state. So, state has to represent the side of victim of crime, prosecution has to represent the case, prosecution government counsel will go in appeal against acquittal order of inadequate sentence, not victim. But in the year of 2005, after the Criminal Law Amendment Act, it has been inserted in by that amendment, it has been inserted in section 372 that even a victim of crime can make an appeal against the order of acquittal or against the order of inadequate sentence. So, how you see, why did Parliament insert this provision in CRPC? Was there any deviance on the part of prosecution? So, you see, when prosecution is not willing to make an appeal against the order of acquittal, or prosecution government advocate is prosecution is not willing to make an appeal against order of inadequate sentence, then what would be the justice? What would be the consequences? Whether justice has been done to the victim of crime. So, victim of crime should be at liberty to make an appeal against the order of acquittal or order of inadequate sentence. So, for that purpose, having that idea in mind, Malimat committee recommended that victim of crime should be given liberty to make an appeal against the order of acquittal or where sentence is inadequate. Another important right in the hands of victim of crime is right to restitution. Victim of crime can file a case against the accused just to get compensation, right to compensation, right to restitution. The purpose of restitution is to put the victim of crime in that position if he or she would have been when their rights would not have been violated by the wrongdoer. So, this is the purpose of status quo ante. So, you all need to understand the difference between status quo and status quo ante. There is difference between status quo and status quo ante. Status quo order is passed by the court just to maintain actual position, but status quo ante order, where order is passed by the court to secure to ensure status quo ante. So, the purpose of restitution order is status quo ante, to put the victim of crime in that position, in place that position in which he or she would have been if his or her right had not been violated by the wrongdoer. So, this is the purpose of restitution. And restitution, rehabilitation, these are the methods through which victim of crime is placed in better position, in which financial assistance is provided to the victim of crime, so that opportunity to take revenge from the accused can be mitigated, can be reduced. So, this is another effective method through which state has to mitigate, state has to reduce the chances of revenge, possibility of revenge which victim of crime can take. Now, come to this third, another important right of victim of crime, right to privacy. You all might be aware that right to privacy is a fundamental right. Every person has right to maintain his or her confidentiality, privacy. Particularly, victim of sexual offence has right to privacy. A victim who has been sexually abused, who has been sexually assaulted. So, a victim of sexual offence has right to maintain confidentiality, has right to maintain privacy and right to be heard whenever prosecution speaks to withdraw prosecution. So, you all might be aware about the law, and Supreme Court has categorically held that in case of sexual offence, the identity of the victim of crime shall not be disclosed. So, every trial court has to ensure that the identity of the victim of crime should not be disclosed. The only purpose behind not disclosing the identity of victim of sexual offence is to maintain, to recognize her privacy, to recognize right to privacy as essential component of right to life or personal liberty. This is another important right. Now, it is, you see, it is important right in the hands of victim of crime that whenever prosecution is going to withdraw cases against the offender, victim of crime can approach the court where prosecution is going to withdraw the case against the offender. So, no criminal case should be withdrawn by the government unless the victim of crime is provided opportunity of hearing. If a victim of crime is provided opportunity of hearing to represent his side in the court of law, then withdrawal would be very tough, would be very typical. I just want to refer a case where Abdul Karim, you all Abdul Karim versus State of Karnataka, Abdul Karim versus Rajkumar film. You see what happened in this case. In Karnataka, a popular South Indian hero Rajkumar, he had been abducted by a smuggler, by sandal smuggler Birappan. He was habitual offender and he was a smuggler also. So, one day Rajkumar film, South Indian film actor, he was abducted by Birappan, and due to as a result of that entire means state was in the state of means people started agitation against the government that popular actor of that state was had been abducted. So, state government decided to withdraw, and he put a demand before the government that Birappan would release that actor, film actor Rajkumar, once his demand, illegal demand would be accepted by the government. So, he demanded from the government that all the charges against Birappan and his guilty partners must be withdrawn, and government decided to withdraw the charges against criminal charges against the Birappan and his guilty partner. Meanwhile, Abdul Karim, who had lost his son in the incident when his son was a police officer. Abdul Karim, he had lost his son in a police operation when his son had gone to arrest the Birappan, and in that incident his son was killed. All the members of that police team they were killed by that dreaded. So, he filed a petition in Supreme Court that before granting before releasing all the offenders, guilty partners of Birappan, Abdul Karim should be heard, and he prayed from the Supreme Court. He made a prayer to the Supreme Court that Supreme Court should intervene in this case. State government should be directed not to release film actor Rajkumar, because it would be futile exercise, it would be of his, it would be a great injustice to his son, to whom he had lost in. So, you see, in this way, when Supreme Court intervened in this case and Supreme Court directed the state government that state government should adopt any alternative method, but this method should not be adopted. Government should not accept all the demand, illegal demand of. So, the point which you see, Abdul Karim being victim of crime, he was father of deceased, he had lost his son, and being aggrieved, being a victim of crime, he filed a petition in Supreme Court that Supreme Court should intervene in this case, due to which state government had to take back its proposal. This is another important. Now, you see this, I have referred three important rights on this slide. This right is available to accused as well as victim of crime. Article 22, right to free legal aid to the accused as well as victim of crime. Right to get medical assistance, this is also important. Right to have a counsel. You might be aware about this right to have a counsel. This right to have a counsel, we oftenly consider this right to have a counsel is available to only accused, not to the victim of crime. But even you see, even victim of crime has a right to have a counsel. Victim of crime can get legal assistance from his counsel, from her counsel, according to Article 22 of the Indian Constitution. Legal representation is a fundamental right according to Article 22, as well as Section 303 CRPC. But here victim of crime is also entitled to take legal assistance from a counsel. Free legal aid, as of now we understand that right to free legal aid is available to a poor people, right to free legal aid is available to the accused, but this right to free legal aid is also available to the victim of crime, where victim of crime is unable to engage his counsel or her counsel in court of law, he or she can get legal assistance free of cost on the cost of the government. So, if he or she, if victim of crime is willing to be impleaded in judicial proceeding, then he may be or she may be impleaded in judicial proceeding and he can get free legal aid, he can get legal assistance on the cost of the government. So, right to free legal aid is also right to get medical assistance under Section 357 CRPC, 357C CRPC, that is newly added provision in CRPC, which also provides that victim of crime is entitled to get medical assistance. So, this is all about your right to have a free counsel. Apart from this, you see, as per recommendation of Malimath committee has recommended that victim of crime should be impleaded in judicial proceeding, so that victim of crime can see the actual working of judiciary, what is going on inside the room, whether his matter is taken up seriously or not. He or she, victim of crime, can see directly, he or she can see personally in the court of law. So, for that reason, impleadment, victim of crime must be impleaded in judicial proceeding. Second important recommendation which Malimath committee has made with regard to the victim of crime, that victim of crime has right to get legal assistance from the government, from the council. Victim of crime is also entitled to get free legal aid. If he is poor, then victim of crime can get. Another important right which victim of crime can claim as a matter of right, that is right to compensation. Right to compensation, as I just want to right to compensation. The purpose of right to compensation is to provide financial assistance to the victim of crime. You see, in Bodhisattva Gautam versus Subhra Chakravarti, AIR 1996 Supreme Court held that victim of crime is entitled to get interim compensation. Even rape victim is entitled to get interim compensation in case of rape. Quickly, I want to highlight the facts of this case. Bodhisattva Gautam versus Subhra Chakravarti. What happened in that case? Bodhisattva Gautam was prosecuted for establishing sexual relationship with Subhra Chakravarti. The facts of this case are: Subhra Chakravarti filed a complaint against Bodhisattva Gautam by stating entire facts in that complaint, that he had given, Bodhisattva Gautam had given false promise to her that he would marry to Subhra Chakravarti, but he refused to marry with Subhra Chakravarti, and being aggrieved, she has come before the court, she lodged complaint to the court, and he committed rape against her. So, considering all the relevant facts, allegations against Bodhisattva Gautam, Supreme Court ultimately held that even rape victim is entitled to get compensation against the wrongdoer. You see, this Supreme Court for the first time in 1996 held that even a rape victim is entitled to get interim compensation in cases of relating to sexual offence. So, in this way, this right to get compensation was recognized as as essential component of Article 21 of the Indian Constitution. And Supreme Court also said that this, where fundamental right is violated by an individual, then Supreme Court and High Court can enforce that fundamental right even against the individual. Another important case on this point where victim of crime can get justice, Nilavati Behra versus State of Odisha, AIR 1993 Supreme Court. You see, being a victim of crime, Nilavati Behra, she wrote a letter to a judge of Supreme Court. She had lost her 16-year-old son, and there was sufficient evidence against some police officers who were involved in that incident, where her 16-year-old son was killed in a police lockup, and in order to convert that custodial death into suicide, that police personnel, they had thrown out that body of 16-year-old boy on the railway track, nearby railway track. You see, when she tried to find out her son, she couldn't find, and then ultimately after 2 days, when a body of that child was recovered, then she wrote a letter to a judge of Supreme Court by stating entire facts in that letter, and her letter was accepted as a letter petition, and in that letter petition Supreme Court directed the state government to award 1,50,000 as a compensation to deceased mother, to a victim of crime, and as a result of that she was awarded compensation of rupees 1,50,000 rupees in that case. Another important case on this point is Chandrima Das versus Chairman Railway Board, AIR 2001 Supreme Court. What happened in Chandrima Das case? Here you see victim victim of crime is not in, where victim of crime is not in position to fight her case due to poverty. They are poor, they are ignorant about their rights. So, locus standi cannot be taken into consideration by providing justice to the victim of crime. So, in this case what happened, where some railway employees had committed gang rape against Bangladeshi women. So, they were poor, they were travelling from Howrah to Delhi, but at Howrah railway station that incident took place. So, since they were not in position to fight their cases, so on their behalf a matter was brought into the notice of Supreme Court. So, one plea which was taken by on behalf of government, that since they belong to foreign country. So, article 21 cannot be invoked against the foreigners. Supreme Court said article 21 can also be invoked against the foreigners. So, even foreigners are also entitled to get the benefit of article 21 of the Indian Constitution. And the important thing is that all the victims, female victims, women victims who had been raped by railway employees were awarded compensation by the Supreme Court. So, Supreme Court issued direction, Supreme Court directed the chairman railway board that they were working employees, they were employee of railway department, they were working on behalf of the railway government. So, chairman railway board was made responsible to provide compensation to the victim of crime. So, in this way you see victim of crime can also get compensation, and the purpose of compensation is to provide financial assistance to the victim of crime. That is a process of rehabilitation, that is a process of restitution. So, these are certain rights available to the victim of crime in our legal system under Indian criminal justice system. What rights victim can claim under Indian criminal justice system, I have covered constitutional aspect as well as statutory aspect and role of Supreme Court in recognition of rights of victim of crime. And I have also highlighted the suggestions made by Malimath committee, so that you can get entire information regarding rights of victim of crime. So, with this I would like to conclude this lecture, and I do believe that you all have understood the things which I have just discussed in this classroom. Thank you all.
I am A.K. Sharma and I teach sociology at IIT Kanpur. I am going to address the question, what is the relevance of statistics in sociology? In India, there is some confusion about role of statistics in sociology, and most of the students of sociology suffer from what I call phobia of statistics. But actually, if you look at history of sociology or the kind of work that are being done in sociology, which are published in prestigious academic journals, you find that there is a lot of use of statistical methods, and not simple methods, very advanced methods. All of you know, as students of sociology, you know that one of the founding fathers of sociology, Comte, or another founding father, Emile Durkheim, they said that sociology is one subject which differs from other subjects in the questions that they try to answer, but they use the same method, the method of science. And that in sociology, those who believe in this kind of approach, they are called positivists. Emile Durkheim called them positivists. they believe that social issues must be studied by using observations, experiments and other modes of collection of data. Now, statistics can help sociologists in three ways. Because if sociology is about social facts or patterns, not individuals, patterns of thinking, patterns of feeling, patterns of acting, behaving, and they can be measured, they can be quantified, and that explanation of one social fact can be given only in terms of other facts. We need statistics, because statistics can measure these facts. Statistics can describe these facts. So, one branch of statistics, we can call it descriptive statistics, can help us in summarizing data, in measuring facts, like you are all familiar with simple statistical things like mean, mode, median, or methods of dispersion, standard deviation, range, variance. These are descriptive measures. They can also be used to measure skewness or symmetry or asymmetry in the data. Other types of statistical methods, which are called inferential statistics, are used to test hypotheses. We know that any science, including sociology, if we follow that positivistic tradition, is about testing hypotheses using scientific methods. And for testing hypotheses, like for comparative purposes, comparing means of two samples or comparing variances of two samples or comparing correlation coefficients or regression coefficients, we need inferential statistics. And if you are familiar with some of them, t-test, z-test, chi-square test, f-test, these are the tests which come under inferential statistics. We use statistics for drawing inferences about two or more samples. And thirdly, statistics can also be used for posing new questions. I remember that a few months ago, I read an article in Population and Development Review in which the authors Cole and Gramajo, they tried to explain homicide rates and variations in homicide rates across countries in the entire world. And they found, based on statistical analysis, logistic regression and all, they found that one factor which explains variations in homicide rates in the world is female education. Not culture, not governance so much, not even male education, but female education. Now, if facts are showing this, so you have a new sociological question: why is it that rise in female education leads to higher homicide rates? And Cole and Gramajo then gave certain hypotheses. You may not agree with those hypotheses. You may conduct this study on your own or test these hypotheses given by Cole and Gramajo using statistical methods. But the point I am making, that in addition to describing data, drawing inferences, statistical methods can also be used for raising new questions in sociology. And of course, you are all familiar that whenever the issue of prediction comes, predicting population of India, predicting urbanization, predicting per capita income of India 20 years from now, 50 years from now, there also statistical methods are of great help. And finally, statistical methods have been used in monitoring and evaluation of development policies run by various governments and NGOs. Thank you very much.